Okay, we're live. Hi, Stephanie.
Hi,
How are you?
I'm good. How are you?
Not too bad. I'm liking the background.
Thank
It's
you.
different from the last time we saw each other. So
Yes, it's very homey. There's a lot of little animals and things going on. It's my parents' like African room, sort of.
okay, a
So,
theme room. I like
it's a
that.
it's a theme room.
It's
So
kind of like the Long Island version of Graceland.
yes, exactly,
There we go. There we
exactly.
go. Well, first of all, I want to thank you very much for doing this. I know even during the pandemic, you've been quite busy.
Yes.
So that's a good thing. And secondly, I want to thank everybody for tuning in to this edition of Did You Know That? Where I have conversations with people I find interesting or about topics I find interesting, even if they may not be interesting. Well, luckily on this one, we get both because I've brought you Stephanie, and I'll let her introduce herself real quickly as soon as I tell you I'm Sean O'Rourke, and I'm a cyber liability consultant at Combs & Company, which is an insurance brokerage and consultancy, and we're actually headquartered in New York City. So now, Stephanie, you're going to tell the world who you are.
Excellent. So hello, Stephanie Roden. I am the owner and founder of Roden Legal PC. I work exclusively with healthcare practitioners in making sure that they're protected as they move through their career from, graduating residency and fellowship up to the point of retirement. A lot of what I do is just making sure that they know what they need to do. So even though I do a lot of contracts and I do a lot of consent forms and I have the legal language, a lot of it is talking them through and really talking them off the ledge to make sure that they understand everything. Because there's a lot of, inconsistencies with a lot of stuff, and a lot of them don't really understand exactly what's needed. So I do enjoy having those conversations and making sure that they understand everything and that they know what their options are before we ever do any type of work. So I really, really get involved with their practices and their careers and exactly what's needed.
Yeah, and that's one of the reasons why I definitely wanted to have you brought on. Well, a whole host of reasons, but that was one of the reasons because as everybody who views this channel knows, my bent is sort of toward the technology, data, privacy, and all of that. And
Right.
so today's conversation is going to be in one of the areas that you do focus on, and that is the acronym HIPAA. And I'm not going to tell everybody what it is. I'm going to leave that to you. But it does involve health information. And since we're in the midst of a global pandemic, health information is all the rage right now. So let's get this kicked off by telling everybody what the acronym actually means, and then we'll go from there.
Sure. So HIPAA means the Health Insurance Portability and Accountability Act. It is a federal law. It involves a number of different fields, not just healthcare. And it's really to help protect the overall public and not having their personal information spread out to the public at whole. I mean, that's a very overall general view.
Right.
The HIPAA, I like to say it's a beast.
You ain't lying about that.
There are so many intricacies to it. I mean, there's plenty that I don't know. And there's a tech component. There's so many different areas. But as a whole, it's really to help, protect the individual citizen of not having their information spread. When it relates to medical care, it's, what's considered PHI. So it's patient health information. And that can cover a ton of different things. There are times where back in the day where, if you had a baby, you would send like a Post-it or a Polaroid of the picture of the baby, and the OBGYN would put it on a corkboard, so like when their patients came, they would see all of these beautiful babies that they delivered.
Sure.
They're not allowed to do that anymore. That's actually considered a breach of HIPAA, because if you can identify the baby from a picture, then it's an automatic breach.
Correct.
So a lot of things have changed just as something as simple as that because of HIPAA. So PHI can extend to photos, your actual name, your address, email address, social security number, your driver's license. It could be even like the web URL that you use, that identifier of your web, which I know nothing about, which you would know about.
Yeah, we won't get into that. Let's not get into the weeds today. At least on that.
No, but it covers a lot of information,
right.
And as practitioners, they really need to be careful of what they're doing with the medical charts or the dental charts or, whatever the records that they're using, because that in and of itself is protected under HIPAA.
So to that point, and that leads into sort of my next question.
Sure.
You said HIPAA is broad in terms of its coverage of, let's say, verticals. It's not just medical. If you can give an example to folks, who else might be subject to HIPAA laws? Is it anybody who holds health information, or do they have to be in specific areas of business practice or what have you to be subject to it?
The next big one is finance. They're a big one for HIPAA. It's most, I'm not going to say it's only about the healthcare, because it's not, but if you have any of these identifying features, it's what covers it. It's all about the protection, essentially. So, finance has a lot of that information. They have the social security numbers, they have the financial wealth, the numbers, the investments, information that are so particular to any person that they still have to go through a bunch as well.
Okay.
But when people think of HIPAA, the first thing they think of, and really the only thing they think of, is really healthcare.
Right.
Because healthcare has much more information than anyone else because of, the medical records, the information that they have to obtain. There are people who consistently go to multiple doctors or maybe one doctor for such a huge length of time that they have so much information on them that really puts together their life story.
Right.
Yes. And if that's ever released, it can be incredibly damaging, especially if they don't want certain family members to know, they don't want work to know, they don't want, whatever the circumstances may be. And that's really where this comes more into play, for the protection.
So to that end, I was going to get to this question later, but since the way you answered it, it's going to bring it up on the list.
Yeah.
Given the current situation with COVID, given the in-place rules for employees to come back to work in cities, states, and again, I'm just talking about the United States because that's all that HIPAA really covers. Right. If employers obtain your temperature, how you're feeling, if you have any symptoms, if they obtain that information and they have to document it in case they get audited or vetted by a state or a city agency, they are then immediately subject to HIPAA rules, correct? Or no? Or is that a gray area?
It's a little bit of a gray area. So, in order to be considered what's called a covered entity under HIPAA, you have to have, information has to be passed digitally, through email, through something else. That's why when you're dealing with insurance, you're automatically considered a covered entity because you're constantly sending information to them. Nothing gets sent by the mail really these days. It's all done electronically. Sometimes you'll get a HIPAA authorization from one doctor to another because the patient has to go to a specialist, and then they're going to send the records via email. You're then going to be considered a covered entity. There's little, and again, there's different tiers to this of how this happens, So
should these companies, though, let's say they're storing the data digitally.
Yes.
Should these companies then be aware, at least, of HIPAA?
Yes.
And what it might mean for them?
There's no question. I had a client contact me, where for obvious reasons, dealing with COVID, they were taking the temperature of employees. And all level employees. It didn't matter because they wanted to make sure not just the health and safety of their patients, but of their other staff, especially when people started to go back to in person. I mean, they had an obligation to be safe and healthy,
Sure.
and they were storing the information on a spreadsheet that anyone can have access to. And I was like, oh, no, you can't do that, because like there was nothing wrong with taking the information,
Right.
but you would have to have a separate file, like almost treat the employees as a patient. Like, even though you're not providing medical care.
Sure.
But it's still information, and the thing is because of COVID, the office or anyone who says that there is a fever or they had symptoms or they tested positive, that information has to be provided to the authorities, to the state, to local, or whoever it was. So they had to have a record of it, and you can't have a record of something if it's just on a Word document or an Excel spreadsheet with all these other people's information, because yes, that could be considered a HIPAA breach. I mean, in the scheme of things, like you would have to get tweaked, obviously, to really figure out whether it's really covered by HIPAA and things like that. But look, if you're just going to do it to just have an overall protection, which is what I like doing with my clients, I think everyone just needs to have the HIPAA privacy rules, the notice. Just do it as if they're covered by HIPAA, because one day, most likely, you're going to be. And if something happens and there's a breach and they come in and they don't see anything that you've done and you don't even have a notice, you're going to get fined incredibly for something as simple that could have been done easily, so.
And so just to let people know, HIPAA is regulated by what federal department?
So it's the Department of Health and Human Services, and then they have in there the Office of Civil Rights. And the Office of Civil Rights it's not just HIPAA. It's anything that goes against discrimination towards anyone. I mean, it's it's the Americans Disability Act. I mean, it's everything, right?
Yep.
But it's the Office of Civil Rights that take control if there is a breach, and they're the ones that are going to review everything, and they're the ones that are going to determine what happens, and it's underneath the Department of Health and Human Services. I recently looked up in preparation for this little conversation. So the max fine per violation now is just under $60,000 per violation.
Right.
So if you have 3 violations and it's at the max, it's a lot of money that they have to pay. Now it can always be less. Obviously, the more violations you have, the more it's going to go up. But you have to really understand that, they don't play around. Like if there's a breach, and that's it.
Right. And this has become a revenue generator for the government. It's just like anything with fines and what have you, that money actually goes to the government, and the government can use that money then.
Yep. I mean, look, in the beginning, back in like 2015, 2016, they were going after hospitals. They were going after the big conglomerates because they had the most information, and there were a ton of breach, where they had that in there, and there was, breach of whoever came into their server and their system. Again, it's tech. I'm so not happy. I'm not getting involved in that. But I mean, there was a ton of things that were going on. And then you got to, as it started to trickle down, you had providers or whoever that had laptops that they would take and use over open networks. They didn't have it encrypted. They would have it stolen, and then all the information is out there. I mean, something as simple as that, which is why a lot of my clients no longer provide laptops to their employees anymore, because they can't afford to have that potential breach, even though it's never intentional. And it has nothing to do with it, unfortunately.
It's what I tell people. You have a cyber incident by accident.
Right. Yeah. And it's just, I really don't think like the smaller practices, I think still have a hard time understanding that they can still be subjected to this. They still think it's the big, huge clinics or urgent care centers or hospitals or like those big type of areas. And it's not the case anymore. I mean, single, practitioners are getting hit with this because they're not doing a HIPAA risk assessment or analysis, or they don't have any rules or guidelines in place. They're not teaching their employees what they need to do. I mean, social media is a huge thing now that they're getting caught on. And the minute that, someone takes a photograph and posts it on Instagram because they think they are promoting the office to let them know how wonderful the decor is and how modern it is. And there's a patient sitting in the background in the waiting room. It's an instant breach.
Right.
And, people don't understand that. And there's all these little things, and it's really difficult to keep an eye on everything, because as technology changes, and technology changes very quickly, and it's very hard to keep up unless you're right in the middle of it, they're going to be at least 10 steps behind.
Yeah. Well, especially in the medical community. I mean, that's one of the reasons why we bonded. I mean, my mother was involved with a private practice for almost 30 years. So I kind of grew up around doctors, and I know their attitudes toward anything outside of medicine.
Oh,
and it's don't bother me. I don't want to know. I don't care.
Yeah. I mean, look, I come from a family of doctors.
That is true.
I'm very well aware of it. I mean, before I opened up my own firm over 10 years ago, I did defense malpractice. I only worked with dentists and different types of doctors and everything else. So I understand it. I mean, their goal is to provide the best medical or dental care that they can for their patients. And they don't have the knowledge, or sometimes even the capacity, to understand all of the other things that they need in place in order to protect them. Mm-hmm. And that's actually what really got me to open up my practice, was because I realized they don't know a lot. And they need someone there to be in their corner so that they can concentrate on the care, and have someone else telling them, you need to work with this one, you need to get cyber insurance, you need to get this type of insurance, you need to have, work with this type of accountant, because otherwise things will fall through the cracks, and that's when the problems start, and then it's going to be too late for them to overcome it.
Right. Well, and then, so again, because we have such a long history together, we've had these kind of conversations in the past, but I want to talk to you about, let's give folks that are viewing this sort of a practical idea without going into too much detail. Let's say they're a medical practice, startup medical practice. What would be your advice to them? Again, let's not go too broad on this. We'll keep it around the HIPAA, but if you want to talk in general, how you advise them to sort of architect their practice and what they need in place, give them an idea of sort of how you run your clients through that initial startup phase.
Okay. So if they're opening up their own practice, whether they're doing it as a solo or with a partner or multiple partners, they need to have a legal entity, first and foremost. In New York, it's a professional corporation or a professional limited liability company. That will protect personal assets. So that's the first thing that they need to do, if they don't already have it in existence.
Sure.
And then you need to get whatever agreements that are necessary for both of those type of companies, and with their potential partners or members, shareholders, again, depending upon the type of company. Then you need to put in place the consent forms. And this is where the fun begins for me. Mm-hmm. So the consent forms is never just about treatment. And anyone who's watching this, including myself, who's saying it, and I'm sure you, your wife, everyone, anytime you go into an office, what do? You get a packet, or you have to go online through their EMR system, and you just keep checking things and signing things and agreeing to things. And sometimes you have no idea what's going on. Those are the forms that I put together.
Right.
Okay? And those forms are there to provide information to the patient about the way that the practice is run, about the type of treatment that they may or may not be receiving, about the risks involved, what alternatives there may be, the financial obligation that they may have for the treatments. Telehealth has now become a huge thing because of COVID. I mean, it definitely existed beforehand, but once no one was really coming into the office, and, still a lot of people don't want to, especially the older generation or anyone who's compromised in any way, they're resorting to telehealth. So you have to have a form about telehealth and the problems with that. And that can be a huge HIPAA breach. What we're doing, we're not discussing any of our health information, but if, this happened and someone walked by me, or there was a technical difficulty, or someone was able to get access to this during it, that's an automatic HIPAA breach if they weren't on a platform that is HIPAA compliant.
Right.
And a lot of them are through the EMR, but Zoom is not HIPAA compliant, not to my knowledge. So
yeah, I don't think so.
So there's a number of things that they have to be aware of, and they need to put that into a consent form. And it's all to make sure that the patient or the end user, whoever it may be, has all of the information in order to make an informed decision that they want to go forward with this. That's really what it's about. So I put all those forms together. Okay.
And those could be numerous. I mean, we're talking,
yeah.
I mean, just to go to my general practitioner for an annual physical, I mean, I'm like, yep, I accept, blah, 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 blah. I've gone through all this.
Yeah. So, I mean, you have the HIPAA privacy notice. You have, you know, the telehealth consent form, the regular consent for treatment form, right? And if it's a place that you're having multiple procedures, there can be multiple forms for each type of procedure. Then you have an office policy form, which normally talks about, you know, if you cancel, you know, 24-hour notice, if you're going to get charged, right, you know, what your responsibility is in the office and things like that. Then you have a financial form, you know, depending upon if they are an in-network provider, meaning they accept your insurance, or out-of-network provider, you know, who's responsible for the payments, what the office will do if they accept Medicare, like what insurance is. Then you can have a patient testimonial, which comes back to HIPAA. So many times people look at reviews to determine whether they want to go to see someone. And this is across the board for any industry. You know, like they may not even go to a restaurant if they see that it has bad reviews. But with providers, that's very important, especially if you're on ZocDoc or you're on any of those other, you know, platforms. You want those good reviews. And patients or potential patients are going to look at it. If the doctor or the dentist want to use any of those reviews or have any reviews on their own website, their own LinkedIn page, their own Facebook page, you need to have actual written consent from the patient, right, to allow them to use exactly what the patient wants to say. And I'm sorry for the phone in the background, by the way.
Okay.
So anyway, and if you don't have that written consent form, then it's an automatic breach. It's the first thing that the Office of Civil Rights is going to come in. Yeah, OCR. I was like thinking of the
acronym. Yes.
But it's the first thing that OCR is going to look at. Like if there is a breach, they're going to come in, they're going to look at your social media. They're going to look to see, do you have anything in writing from any of these patients that allow you to do this? And each patient can be one violation. It's not just a whole violation.
Oh, no. Yeah, that's the thing. Yeah.
Separate. So technically, if you have 10 testimonials on your webpage without a single written consent, that's 10 violations, at most 60,000 each one.
Yep.
Without them even getting into anything else.
So let's take a quick detour because I warned you that you might say something that springs to mind a question. Let's say I'm on LinkedIn, and let's say you're a doctor and I go to your profile and I give you a recommendation on LinkedIn because that's where I operate. I don't go to Yelp. I don't go to Google reviews. I go to LinkedIn. And I give you a testimonial through the recommendation saying that you are my doctor. Mm-hmm. How is that handled now? Does the doctor retroactively have to send you a consent form, or by posting that, is that essentially a de facto consent form? Because again, I only play a lawyer on these videos. I'm not one in real life. So that just popped into my head. How would that work, do you think?
It's interesting, but you have to think, if the patient is going to give a testimonial, that means that they've already treated with them. Generally, right? Right. If they've already treated with them, that means that they've already signed forms. That patient testimonial form should have been in the original packet. So then there's no issue. If they don't have it and the patient does it, yeah, it's a, you know, I don't know what would happen timing wise if they got it afterwards, you know, but they would need to have some type of written consent. It's why I put it into the initial packets, you know, for the consent form. So this way they don't run into that. The reviews that are on any social media that are controlled by the doctor. So their personal Facebook page, personal meaning it could be their own or it could be the practices, but something that they actually have control over. Facebook, LinkedIn, website. If they have control over it, then they have to have the consents in order to use, no matter what. If it's using, you know, a patient post on Google or Yelp or ZocDoc or something like that, they have no control over it. They don't need the consent for that. But if they want to actually grab the consents and move it to put it onto their own page, then they would need to get the consents.
Okay.
So a lot of it comes down to whether they control the site or not. And that's really what it is. So
LinkedIn, you would assume they control their LinkedIn profiles, so they would have to have something.
Absolutely.
Okay. But let's say they didn't proactively do it, they ignored your advice, they didn't get the consent form. Would you recommend then or advise them to get it posting of that recommendation, given the scenario I just gave you?
I mean, anytime that happens, they're better off having something in writing consenting to these, no matter how you look at it. Each is on a case-by-case basis, and I'm not allowed to give advice technically, but recommendation is, the first thing I would say to anyone who contacted me with that type of scenario is, let's figure out exactly timing and work on this. Providers should have, I'm not saying they should have their attorney on speed dial, but everyone should have an attorney that they know that can answer these type of questions or that they have a relationship with, because the quicker that they can respond to these certain ideas or items or issues, the better off they're going to be in protecting them, the practice, and the patient.
Okay.
It always comes down to protection. And me for years. It's the one word that I use all the time. It's all about protection. And again, it's not just, my role when I work with my clients is to protect them. But in essence, by protecting them, you are protecting the patient, because how they operate their practice protects the patient, and the patient's going to feel safe. And that's what they want. Reputation is everything. And if something happens where patient information came out, or there was a HIPAA breach, or they had to pay some type of fine, first off, that's public record. Anyone can find it. And there goes your reputation, and no patient's going to want to go if they think that their information is going to be passed along or provided to someone else, or there's going to be a breach of it.
Well, to that point, and you've mentioned this before, you're not a techie, so your protection is from the legal standpoint. What they do from a technical standpoint, that, again, HIPAA does actually have technology requirements that are, fairly detailed and whatnot, actually pretty well put together. What the doctor does or what the practice does subsequent to you telling them, here you go, all your documentations are in place. What you do after that is sort of beyond your scope, but you can tell them, you better have your act together when it comes to your technology.
Oh, absolutely. It's why I work with, it's how you and I first met, but it's why I work with, a ton of companies that are, IT specialists and have something dealing with HIPAA, because they need, they being the providers, they need that person. And it's not just about making sure that, their server works and that they can send things. It's about making sure that it is as HIPAA compliant as it can be. And I hate the word compliant, because I don't think anyone can ever be completely HIPAA compliant, because there's too many different aspects to it. But if you run the risk analysis, the risk assessment, you have actual guidelines in place. You show that you've had meetings and lectures and seminars to your employees so that they understand what they need to do. And it's documented, and the employees are signing off that they understand. All of that is helpful, even if there is a breach, to show that you did what you can do, because a breach can happen without fault. You know that.
Yes. Oh, yeah.
And that's, as horrific and horrible as it is, it doesn't mean that you necessarily did something wrong. It's very similar to malpractice. Just because there was a bad outcome, it doesn't mean that there was actually malpractice.
Right.
But if you don't have the things in place to prove that you did everything that you could do to prevent that from happening, then it's going to look like you did it and that it could have been prevented. And that's really what all this is about. So there's the legal concept of it where, you have the documents in place to protect, and the tech component of HIPAA to make sure that you're actually putting the regulations in place on the tech side to actually protect what the written language is saying. And without the two meeting, they're both worthless.
Yeah. And look, I've read through the tech requirements innumerable times in my career. And there is, I mean, even massive hospitals can't meet 100% of it. So we always went by the 80-20 rule. You got to meet 80% of the most important elements. The other 20% are almost nice to haves. If you can get to them, great. But for the most part, small, mid-size, even larger practices are not going to be able to get to there because it's just fiscally irresponsible. You put yourself out of business trying to reach that point.
Yeah, and look, and there are like checklists type of thing of what like you really should have, and if you're working with the IT professional, they should know this, and if they don't, and you're in that field, then you're not working with someone who's really going to be able to protect you, and I mean that in the nicest of ways, to make sure that they're working with someone, because there are a lot of companies out there that say that they do understand, but they really may not. And if they can't meet the most basic of those requirements, or they don't understand it, then they're not the right fit for a practice, because the practice needs to make sure that that's there.
No,
and
I agree.
And it
I
also
totally agree.
And it also needs to be done, I would say yearly, to make sure that the guidelines and everything, because, as I started, HIPAA's a beast. It's changing, and it does change. I mean, it's just like the human body. It's just things are always changing without our knowledge,
Yeah, unfortunately. Yep.
So you definitely need to make sure that you are staying up to date. And by working with people in their professions that understand this, will ensure that. But you just have to make sure that you're working with the right people.
So to that end, I always know you're the right person on this topic. And I know we try to keep these to a half an hour, but you and I are going to go over because I have a couple more questions for you, if that's okay.
That's perfectly fine.
Okay. So outside of the medical practice, given the COVID situation, given what employers may have to do to bring employees back to the office, let's say somebody outside of the medical field came to you, and again, you're not giving advice, you're just sort of spitballing with me right now. Let's say they came to you and said, okay, Stephanie, I've got a 30-person office. I'm trying to bring people back in some sort of safe, methodical way. What do I need to have in place to protect me from the new types of information I have to collect on my employees' health? Again, we're just spitballing because I'm just throwing this out there. So
look,
remember, everybody, any state bar association, this is not advice.
So first I would say, thank you for coming. No, I mean, look, in the end, you have to file the state and government guidelines, CDC, the WHO, and just make sure that you're doing what you need to do. You have to be on top of all of that. And those are constantly changing. I mean, Cuomo just added 2 more states to the list of those states where if someone comes in, they have to quarantine themselves for 14 days. It's constantly changing based upon what's going on around the country. You should only have a certain percentage of employees, and they should be the people, the employees that are there that need to be there, that cannot work remotely. So like the receptionist or the administrative assistant, they can probably do their job at home. They don't technically need to be there in person if they have access to everything at home, right? So you have to look at that. The questions that you're going to have to ask are still the same questions. Have you tested positive? Have you been around anyone that's tested positive? Have you been exposed to anyone who's been to any of the states that are listed? Have you any of the symptoms? And list the symptoms. Have you experienced any of these in the past 14 days? Have you had a fever? Have you traveled out of state? Have you traveled out of the country? Now, no one can really travel out of the country that much now because no one's accepting Americans at this point in time. But, those are all questions that you want to ask. You want to make sure that you have it documented. You want to make sure that they understand this. You should put it together in protocols or guidelines that get sent to every single employee so that they know what's going on. Everyone who comes into the office has to make sure that they wear a mask. Employers should be providing the masks if they can't get access to it. Maybe you have access to gloves. Some people are still wearing gloves all the time, out of fear. You want to make sure that, you have the sanitizer. that you are sanitizing the area, that you're cleaning all the common areas, anything that's being touched, doorknobs, light switches, countertops. You want to make sure that those are being constantly cleaned when you come in, when you leave, and throughout the day. If you have, clients coming in, you don't want anyone waiting in the waiting room. You want them to come in and go straight into whatever room that they're going into. No dawdling around, no guests. It's just the people that you need to meet there. You want to reduce the number of people as much as possible, because when you're in an indoor space, from what information that I have, it increases the chance of exposure because you're more confined.
Yep.
It's just common sense, really. But
yeah, look, less air movement. The virus can't blow out of your path. It's just kind of sitting there.
Yeah. So there are certain things that you can do. And when and that's across any industry. It would be in my office. It's one of the reasons why I'm not back in the office yet, and I'm not having any of my employees back in the office, because we can all do it remotely.
Yeah.
And if I do go back in the office, it will most likely just be me, because I don't need to have anyone else there. I don't need to expose them for this, whether it's a high or low risk, there's no reason for it.
Well, your answer just explains why most big companies have said nobody's coming back until 2021, at least in New York City. Again, the rest of the country has its own protocols or needs.
Facebook just did that, I think. Facebook said no one's
Google
coming
said
back.
that. Spotify said that. Anybody with more than 10 employees, I think, is thinking, you know what? It's not worth the hassle. It's not worth the expense.
Well, the thing is that, even though, look, this virus in the States has only been out for a couple of months, at most 6 months, maybe going on to 7 months, since the very first case earlier this year.
Yeah.
But no one really knows, one, how long this is going to last, what really is going to happen, or really how people truly get exposed to it, because everyone is different. You can have an employee come in, wear a mask, wear gloves, you're cleaning everything, and they still get it. Yep. And then can you trace it back? And that's the big point. Can you trace it back to exactly that it's because they came into the office, or was it because they were on the elevator, or was it because they took, they commuted to the office, so it was because of the subway or the bus or being in an Uber? Like, you have no idea where that is. But as an employer, I can say, I don't want that responsibility. I don't want any of my employees to be even remotely exposed. I don't want them to get sick, first and foremost, but I don't want the liability.
Sure.
And you're not going to be able to really control that, because it's so unclear of how people really are getting it. When I hear about, people having COVID parties to see who can get infected across the country, it's a little frightening to me, because you really just don't know.
Yeah. Well, and again, as we said, everybody's situation is different. I tested positive in early April of 2020, depending on when anybody's watching this. I had absolutely no symptoms. So back then I wasn't eligible to be tested, but the reason I did get tested is because I drove my wife, who basically had a cold, to get the testing center, and the nice National Guard there says, "You want to get tested?" And I said, "Sure." And so that's how I found out. And then a week later, 10 days later, I think, we tested positive for the antibodies. Yeah. So our experience was like that, and we were kind of done on that front. But I can't tell you any way, shape, or form how either one of us, I keep blaming her that she gave it to me, but I can't tell you one way or another how we would have gotten exposed to it.
Look, I ended up, when all of this started, I quarantined myself by March 17th, before the official lockdown of New York City.
Sure.
20th. And, I wasn't feeling well, and I didn't know if it was psychosomatic because of everything that was going on, and I had certain symptoms that were not known symptoms back then, because it wasn't the fever, it wasn't the chest pain, it wasn't the cough. It was, extreme headaches, fatigue, loss of taste. None of that was part of it at the time. And, since then I've gone and gotten tested, and I've tested negative for the virus. So it was never, active in my body, but I tested positive for the antibodies. I don't know how I got it, because everyone who I was around before I technically got sick all tested negative for the antibodies. So I have no idea.
So somebody walked by you you walked by them, they had it, you breathed it in, and then that was it.
I mean, but yeah, I mean, look, to go back to the whole, protecting yourself and, specifically for providers, having all of the information in writing and trying to give as much information to their patients, to their staff about, COVID, about, just how the office operates on a general level, the better off that they're going to be. And that involves obviously HIPAA, and it's all about privacy. It's all about the protection, and it's making sure that your office is run the best way that it can be in order to avoid any information being leaked, breached, or put out into the public without your knowledge. And that's really what it's all about. And it's just, and that's how everyone, regardless of industry, in all honesty, how I feel, everyone should operate, because no one wants any of their information exposed for absolutely no reason.
And guess what? We're going to end that on a high note, because that was perfect. Hey, I really thank you for doing this. We went above and beyond our half an hour, but I think it went much faster than even I expected it to go. And we didn't even get to a couple of the questions that I had. So maybe we'll have to do a part 2 down the road.
I would love that. I love always doing this with you, Sean. So
you know what? Actually, what we're going to do is we're going to try to wait and do it to where we're in the same room together. We may be 6 feet apart, but we're going to try to do it where we're in the same room. Okay.
I'm down. Count me in.
Well, Stephanie, I appreciate it. Thank you very much. And to everybody who's viewing the video, thank you for your time. Hopefully you got something out of this. If you didn't, then you weren't really listening, because Stephanie gave a lot of good advice. And if you like these videos, be sure to subscribe to the channel. And until next time, thank you again. See you, Steph.